It's very easy to say we interpret the Constitution according to its original public meaning, which as I appreciate your testimony, means the way people who read the Constitution at that time interpreted it. Is that right?
Yes, Senator.
Okay. Do you think that most people at that time looked at the United States Constitution and said, well, here it is, big as Dallas, racially integrated schools are required? Do you really believe that?
Hey everyone, welcome back to Congress Lens. Audrey here, and wow, this clip of Senator John Kennedy questioning a constitutional law professor? This is one of those moments where you watch and realize why Kennedy is feared in every hearing room. The senator came in with clarity, precision, and zero patience for academic dodging. And honestly, it was refreshing to watch. Right from the start, the professor tries to dance around the meaning of original public meaning, and Senator John Kennedy instantly stops the spin. Professor, look me in the eye and just answer my question. That line alone sets the tone. Kennedy wasn't looking for a lecture. He was looking for clarity, and he absolutely demanded it. If you're new here, make sure you like, subscribe, and tap that notification bell so you never miss content like this. And if you think more people should see moments where senators get straight answers, share this video. Let's get into it.
Kennedy.
Professor, congratulations. I believe you testified that you think the Constitution should be interpreted according to its original public meaning. Is that right?
Yes, Senator.
What does original public meaning mean?
Yes, Senator. So the original part of that phrase refers to the fact that when we look at interpreting a text, we want to interpret it. At the time it was...
Professor, look me in the eye and just answer my question. What does original public meaning mean?
It means the meaning that the text as it was understood by the public at the time it became law.
Okay. So you think Brown v. Board of Education was incorrectly decided?
Well, Senator, I think Brown versus Board of Education was correctly decided. Scholars who have looked at the original meaning of phrases at that time and the reasoning in that case sometimes question the reasoning of the case.
How many people in the United States of America at the time the Constitution was drafted do you think supported racial integration of schools? You think that was a majority view, do you?
Well, Senator,
but first, Professor, do you think that was a majority view? Do you think most Americans at the time the Constitution was drafted supported integration of public schools, racial integration?
Well, Senator, I don't know as a sociological matter what percentage of people thought what at that time. I should point out that when we got to Brown versus Board of Education, of course, there had been several fundamental amendments to the...
But isn't that inconsistent with your statement that you have to interpret it according to original public meaning?
Well, what about the 14th Amendment and the 13th Amendment and the 15th Amendment? So original public meaning would mean with those... Well, that would mean we would interpret those amendments and those protections with the understanding of the text and structure at the time those amendments were ratified, which is different, of course, in the 19th century.
Let's go back to Brown v. Board. Look, I think Brown v. Board was correctly decided, and I suspect you do too. But if you say we interpret the Constitution according to the way that people at that time understood it, do you really think that people at that time in America supported racially integrated schools? Do you really believe that?
Well, Senator, I think at the time of the ratification of the 13th, 14th Amendment, and 15th,
But do you think people at that time supported integrated schools?
Well, Senator, on that particular question, I don't know it as a policy matter whether they were thinking about that particular issue. I think they certainly understood that the 14th Amendment, for which a massive part of this country essentially lost lives fighting the Civil War, certainly understood it to require racial equality.
You're not answering my question. I'm trying to understand I'm just trying to understand how you think. It's very easy to say we interpret the Constitution according to its original public meaning, which as I appreciate your testimony, means the way people who read the Constitution at that time interpreted it. Is that right?
Yes, Senator.
Okay. Do you think that most people at that time looked at the United States Constitution and said, well, here it is, big as Dallas, racially integrated schools are required? Do you really believe that?
Senator, I don't know, but
And if you don't, I don't think you do, because I think historically that wasn't the case. So how do you square that with the holding of Brown v. Board?
Well, I guess what I'm trying to say is I think there are several steps in between that have not come up yet in our conversation, which is that you look at the text and structure, which of the 13th, 14th, and 15th Amendments clearly is requiring racial equality. And then over time, that has to be applied to different questions as they arise in context. So if the requirement is that all races be treated equally under the law, and the evidence shows that segregated schools is not doing that, then the requirement could be applied to integrate schools.
When you interpret a statute, you talked about interpreting it according to its plain meaning. What if the statute is ambiguous?
Well, Senator, if the statute...
What do you do if it's ambiguous?
If it's ambiguous on the particular question coming before the court, I start with that phrase, but I also look at the context of surrounding provisions.
No. I understand you define ambiguity as the language plus the surrounding language.
Yes.
I get that part. How ambiguous does it have to be? 51% ambiguous or just a little bit ambiguous?
So I have to say I would use the same approach essentially in all cases regardless of the ambiguity, because I would always start with the text, move to the surrounding provisions with the aim of fully understanding what Congress and the President had enacted. And only at that
Professor,
point...
I'm going to run out of time. With respect, answer my question.
Well,
okay, you're giving me professor talk. How ambiguous does it have to be?
I mean, I think under the Supreme Court's recent precedent in Chevron, it underscored that the court can never just rest and say it's ambiguous. The court has to come up with an answer.
Yeah.
So
why don't you just look at legislative history?
Well, you can't look at legislative history of statements one by one because the individual intent... Well, Senator, with respect, because this body has its role in our system as an institution, not one by one. So your personal understanding of the law doesn't matter.
This will be my last question. I'm sorry. Coons went way over. So you're telling me that it doesn't help you at all to go through and look at the congressional record or read the committee reports or any of that? You don't think that's helpful in interpreting what a statute means?
It depends on the way in which it's being read. If it gives helpful statutory history, if it helps to refer to other portions of context, sure, but not to give it legally binding impact in and of itself. I would always be looking at a broad range of sources and use each of these statements as just one piece of evidence about what people understood the statute to mean at the time. So no, I would never take a piece of legislative history in isolation and give it legal impact.
Thank you, Madam Chair.
Thank you.
We just watched the whole thing, and let me tell you, Senator John Kennedy was on fire. From the moment the questioning began, Kennedy made it clear this wasn't going to be a philosophy seminar. This was going to be a direct examination about how constitutional interpretation actually works when real rights and real people are involved. The professor technically answered questions, but let's be honest, the responses were wrapped in layers of academic buffering. Kennedy wasn't having it. He kept pressing, narrowing, and redirecting until the professor had no escape route except to confront the actual implications of the doctrine. And Kennedy's main point was razor sharp. If someone claims the Constitution must be read through original public meaning, then how do they reconcile that with decisions like Brown versus Board of Education, a decision we all agree is morally and legally correct? When Senator John Kennedy asked whether Americans at the time of the Constitution's drafting supported racial integration, the professor could not answer. But because history makes it obvious. Kennedy exposed a major gap between the doctrine the professor defended and the moral outcomes that doctrine must still produce. And Kennedy didn't attack, he clarified. He showed the difference between theory and reality. He showed why vague, evasive answers matter. And he showed why senators must press nominees who want lifetime judicial appointments. Then, when the conversation shifted to statutory interpretation, Kennedy did what Kennedy does best: cut through the fog. How ambiguous does a statute have to be? Why not just read the legislative history? These are simple, practical questions that determine how judges actually rule, and yet the professor kept circling. And every time the professor dodged, Kennedy pinned the reasoning back down to earth. By the end, Kennedy revealed the core issue. The professor wanted to treat congressional intent as optional, but Kennedy made it clear that Congress writes the laws, not scholars, not agencies, not creative interpretation. And that matters. This was classic Senator John Kennedy: sharp, informed, and unwilling to let theoretical gymnastics replace common sense. If you agree that hearings need more moments like this, let me know in the comments. If you disagree, tell me why. This is Congress Lens, and we break down these moments honestly. Thanks for watching. Audrey signing out. See you in the next one.